Good evening, everybody. You are welcome to this month's edition of our monthly clinical meeting of the Nigerian Society for Colorectal Disorders. This month, we are going to have a special outing with one of our great teachers, who is a surgeon by excellence and also doubles as a legal luminary. It is my pleasure and honor to welcome Professor Clement Osimen, who is a professor of surgery and a surgical oncologist, and also a barrister and solicitor of the Supreme Court of Nigeria. He is also a notary public. And being a clinician, being a doctor and a surgeon, and also being a legal practitioner, he wants to take us through a very important aspect of our practice, and that involves the medico-legal aspects of clinical practice. We all know that we are in the era of litigations, suits, and all sorts of things. And we cannot pretend as if we are not aware of some of this happening. And considering our area of practice, a resource-limited environment in which the citizens or the patients expect us to perform optimally as if we are working in the Western countries where everything is available, we need to call ourselves to some of these things so that we can guide ourselves as we are caring for our patients. We also care for ourselves. So it is my honor to welcome Professor Osime as he takes us through this lecture this evening. And let me say that this lecture is recorded and will be posted on our YouTube page for people to access even after today's meeting. Prof, you have the floor, sir.
All right. Thank you very much.
Thank you, sir.
Dr. Dejumo, I want to appreciate the leadership of this body for inviting me to do this talk. Are you hearing me?
Yeah, we're hearing you loud and clear.
Yes, sir, loud and clear, sir.
Okay, all right. So I want to appreciate the leadership of this body for inviting me to make this presentation. This is the outline I shall be using, and I want to appreciate Adejumo for that introduction, because we now live in a very litigious society where the era of patient those days say, oh, that's the will of God when the patient dies, or there's a mishap, or they think that the doctor knows everything. That era is long gone and may never come back again. Because our patients have become increasingly aware of their rights. Therefore, as surgeons, we must do all we can to avoid litigations. Now, who is a surgeon? Simply put, a surgeon is somebody, a doctor who specializes in evaluating and treating conditions that may require surgery or physically changing the body, the human body. But we need to note that the best surgeon is indeed that surgeon that knows when not to operate, meaning that there are some situations where ordinarily a patient thinks you're going to operate, and you don't operate, because if you have to do an operation and there's a mishap, your colleagues who are in good standing can take you up. Now, why did you have to operate on this condition that should have been managed non-operatively? Now, what are some of the qualities of a good surgeon? Number one, we must be cautious and have good listening skills. We must also have good communication skills. Otherwise, you're unable to let patients know what you actually try to pass across to them. We as surgeons must demonstrate empathy for our patients and also their relations. We must be relaxed, polite, and maintain a friendly attitude and disposition at all times. You see, this has relevance when there is a mishap. If you've been hostile to a patient and there is a mishap, you can be sure that patient is more likely, the threshold for litigation very low. Unlike a situation where I'm very friendly with a patient, when there is a mishap or even death, the family may not think of litigation because you have been quite friendly with them. So it's good for us to maintain a friendly attitude. Of course, as surgeons, you must sharpen your surgical skills at all times, willing to learn and improve on your skills. And again, your specialty, you must try as much as possible to enhance the skills in your specialty. And I dare say here, stick to your specialty. To that extent, for example, if you're not a plastic surgeon, I do not expect you to go and be doing plastic surgery procedures. If you're not a urologist, maybe you're a general surgeon, as much as possible, try to stick to your general surgery procedures. Because when you have complications, it may be difficult to explain. Somebody can quiz you, oh, you're a general surgeon, what was your business going to do hysterectomy? Now you have tied the ureters and all that. A good surgeon should be able to keep medical information confidential, no matter the circumstances. Should relate well with colleagues and other members of the health team. And again, you should have ability, to have detailed documentation. This is very, very important. Ability to maintain some problems for the front. Times you don't document your findings, maybe intraoperative and all that. And when an issue comes up, it becomes difficult for you to explain why the injury may have happened and all that. Documentation is quite important. Now, on the other hand, who is a patient? A patient is someone with a health challenge in whatever form, may require the services of the surgeon. That patient desires to be shown love, adequate care, and empathy by the surgeon. Along this line of expectation, the surgical patient comes to meet you with that in mind. And once there's a deviation, you don't show love, there's lack of adequate care, you are not empathetic, that patient, if there's a mishap, is likely going to go for litigation. Now, we need to talk about the duty of care in a law of tort, which is a legal obligation levied on an individual, requiring your adherence to a standard of reasonable care while performing any act that will possibly occasion harm to another that is reasonably foreseeable. A surgeon, you are going to do a surgery. You know that, oh, if you didn't cross-match blood for a very bloody surgery, that patient could bleed intraoperatively and die. That risk is foreseeable. And any reasonable human being is advised to take precaution, to make preparations to ensure that harm does not come to that patient. Now, we need to understand that once a surgeon has taken up the duty to treat a patient, a duty of care automatically arises. Now, it doesn't matter whether you are doing it for free or you are doing it for a fee. Once you have taken up a duty to care for a patient, we will be careful with this, where we treat family members, friends, relations, church members, when you offer free services. That you're offering free services doesn't mean you should render care with less importance. You must render care with the same zeal, with the same skill you render if you are collected a fee. And the surgeon is expected to conform to the reasonable standard of an ordinary surgeon of his training and skill. We do not expect you to be an A1 surgeon. Just be the average surgeon you can be. Your attitude, you should conform with what a regular surgeon would do, working under the same circumstance as you. Now, we must work toward respecting the rights of the patient in terms of the duty we owe to our patients as surgeons. Our basic duty is to work at all times to protect the rights of the patients. And therefore, we cannot discuss this further without first identify the rights of these patients. It is when we infringe on the rights of these patients, the issue of litigation can come up. Number one, our patients have right to medical care of good quality. I put good quality in red, because if a patient comes to meet you, for example, you're a person on call, you are not found to render care, you leave your residence to take decisions, maybe the decision they took, they didn't even discuss with you, you didn't supervise them properly, and they went to do an operation, for example. Without even, maybe you didn't have a direct input. If there is a mishap, that patient can claim very confidently that he didn't receive medical care of good quality. A patient, you have right to freedom of choice and right to self-determination with regard to the accepting operation or not. That will involve issue of consent and discharge against medical advice. In terms of consent, you want to do a procedure, you must explain to the patient. Recall we talked about good communication skill, the operation you wish to do, the complications that could follow if it's not done, and the possible complications of even the surgery. You must explain to the patient. And when it's been properly informed, they have to have freedom of choice to either accept the surgery or decline. And indeed, if it's been on admission also, the patient has the right to say, doctor, discharge me. I want to leave against medical advice. Of course, they have right to information. Most doctors are guilty of this. When the patient says, please, can I photocopy my result? And you are holding it. That is wrong. The patient has right to his information. You can photocopy results and give to the patient. Of course, right to confidentiality. Whatever you see in your surgical patient is not meant for you to discuss outside that circle. The discussion must only be on what you call on the need to know basis. Outside that, you have no real business discussing the patient's clinical condition, even with other colleagues who do not need to know about that clinical condition. Of course, the patient has a right to dignity. Apart from having their own rights, they equally have responsibilities. And as surgeons, you must know these responsibilities, because a knowledge of these responsibilities can offer some, protection to you or some defense in the event of litigation. We'll come to that shortly, what you call, contributory negligence. They should give information about themselves, complete and accurate information about themselves. They ought to seek information on any aspect, particularly when issues are not too clear to them. They should keep their appointments, and if they want to reschedule, they should give you information. They should treat you as a surgeon and other patients and visitors with respect and courtesy. They should obey rules regarding their own health. I'll give an example here. I mentioned contributory negligence. You tell a patient, nothing by mouth tomorrow. You are going for surgery. And you've done your best, you've told the nurses, this guy, maybe he hid a bottle of Coke in his pants and went to the restroom to gulp 2 bottles of Coke. You are not there to know that. If that patient vomits under anesthesia, he had disobeyed the rule regarding his own health. And if there's evidence, one way or the other, to confirm that he took Coke by 8 a.m. while his surgery was for 9 and he vomited and aspirated, we call that contributory negligence. They should inform the hospital if they have a living will, durable power of attorney, or other directives that could affect their care. Now, what is our duty towards the patient as surgeons? I put it in red again, which I mentioned in passing earlier. Our duty essentially is to work at all times towards protecting the rights of the patients I mentioned a while ago. We must give them good standard of practice of care, adequate assessment of this patient when they come to meet you, appropriate investigations, appropriate treatment, prompt referral when indicated. If there is a case, a neurosurgical case, I'm a general surgeon, I should not hold on to that patient for longer than necessary. I must refer promptly. You don't refer the patient when he's almost gasping, say go and see a neurosurgeon. That will be my practice. We must work within the limits of our professional competence. We must be willing to consult with colleagues. You should be competent when you are making your diagnosis or providing treatment. You should keep clear, accurate medical records. That again, I put in red. Most of us as surgeons, we are guilty of this. We must keep clear and accurate records. You must pay due regard to efficacy and use of resources. Know the resources available in your environment and use them judiciously. Prescribe only the drugs and treatments that the patient require. Do not allow maybe drug companies or other considerations to make you to do procedures that the patient ordinarily doesn't require. Because if you have complications in the process, you may have to give some explanations. Ensure your prescriptions are written correctly and clearly. You must abide by hospital rules, protocols, and standard practice. I'll quickly explain this. For example, you may have an hospital that says you do not do any elective procedure on the weekend. They have their reasons for saying that. But somehow, maybe because you have a friend who says, I don't want publicity. Can you please help me do the surgery on a Sunday when the theater, the hospital is quiet? It's your friend, a very good reason. And you went ahead to do maybe a partial gastrectomy for a very good friend. Unfortunately, you encounter very torrential bleeding. Blood bank doesn't have enough blood to support you, and you run around, you can't get blood. That patient bleeds to death. If that happens, for example, your hospital can conveniently, first of all, deny you and you took a wrong step by not abiding by their rules and protocols and standard practice in the hospital. But the rule is don't do elective on the weekend. You are no business doing partial gastrectomy on a weekend. So we must take care of that. For people that want to do intramural practice and all that, you need to define it to be sure you are covered and the management is carried along as you do your intramural practice. You must keep your knowledge and skills up to date. You must observe and keep up to date with the laws and codes of conduct in this case, the Medical Council of Nigeria. We must take part as surgeons in regular and systemic clinical audits. We should also respond constructively to assessments, evaluation by your peers regarding your performance or your competence. Don't quarrel. It is when we disregard such corrections at clinical meetings that eventually you may end up one day having litigations. Do not recommend investigation or treatment that is not needed by your patients. Now, this is very important. Make suitable plans for your patients who are not around. So important. Most of us as surgeons, we are guilty of this. You operate on a Friday and you just disappear. No concrete arrangement with your colleagues to say, I've done a major surgery and my senior registrars are around. Perhaps if there's an emergency, please help me to look in as what is happening. Yes, you may have told your senior registrar, if there's a problem, call Dr. A, my colleague. Did you tell your Dr. A colleague you are traveling? Because that Dr. A may not be in town, for all you care. May have traveled to go and vote, for example, and it's not bad, just as you did. It's just an assumption. Oh, he hardly travels. Please make suitable plan for your patient when you're not around. We must delegate duties reasonably. Don't give duties to your residents when you have not tested them and they can do that duty. Because if there is a mishap in the process and there's evidence to show that that resident has not been properly trained in that act delegated to him, then there's a problem. We say delegation doesn't mean abdication. Even when you delegate duty, it is your responsibility to keep a close watch, monitor, to ensure that that duty is executed carefully and diligently. You must give correct information about your services. For example, a client comes to your clinic and asks you, doctor, are you a urologist? Don't say, oh, I've done 100 prostatectomies in the last 1 month. In a multitude of ways, you have simply confused the patient to assume you're a urologist. The answer to that question is yes or no. I'm not a urologist. It's left for the patient to ask you, my father has enlarged prostate. Are you able to do prostatectomy? There are two different events. You cannot say, yes, I've done some and that. But when the question is posed to you, what is your specialty? Declare it truthfully without trying to beat about the bush. Avoid conflict of interest with your patient. If there is a conflict of interest, maybe you have an issue with the patient, you had a quarrel, and you are not comfortable to continue with that patient, it's best for you to hand over that patient to somebody else. There should not be any undue advertisement about your skills, but it doesn't mean you cannot tell people what you can do, if particularly have some specialized form of training. We must act in the best interest of the patient when you are referring them. You shouldn't be referring to somebody because they will give you a kickback, what you call a fee splitting. That is infamous conduct in the professional respect. Now, we've gone through some of the responsibility we owe our surgical patients. As a surgeon, you also have your own rights. Number one, you have a right to legal protection while performing your duties in compliance with professional and operational standards. That's very important. Remember, I said right to legal protection, provided you are doing your duties in compliance with operational standards. For example, I say it again, you are this general surgeon on call. You are not going to be found in the hospital. Somebody had ruptured spleen that requires surgery, and you didn't come, they didn't see you. That patient bled to death. You did not behave in compliance with professional and operational standards. And to that extent of not complying, you do not have the right to lay claim to the legal protection. We need to understand that. We also have right to provide healthcare services in compliance with professional and operational standards. That means nobody, not even a CMD, not a governor, can make you to do a wrong thing. You have the right to do it in the way it should be done according to operational standard. You have the right to refuse patient wish that is conflicting with rules and regulations, with professional standards and ethics. For example, I said the level of amputation. A patient has a very useless limb, for example, that need to be amputated above knee. And the patient said, no, just please, sir, remove it only below knee. Or they may require disarticulation. You do not have to now say, okay, patient says I want a below knee amputation. When you know what that patient ought to have is a disarticulation of that limb, you will say, no, that is not in line with my teaching. This level of amputation you are requesting does not fit the condition you have. So it's important we are able to maintain our position as surgeons. Of course, nobody can compel you to see a patient at accident scenes. Remember this, if you however stop at accident scene to give care to a patient, you must give standard care to that patient. Recall I said, whether for a fee or ex gratia, pro bono, you must do what you need to do. If there is an ethical or personal conflict with your patient, you must withdraw your services, but recall the method of withdrawal. You don't just withdraw. Maybe a patient insulted you, and during ward round, you no longer get to the patient bedside. President will go there, take decisions. When they finish from there, you join them in the round again. Next day, they come again, they take decisions, you don't make any input because you had a quarrel with the patient. If that patient, for example, has a complication and is able to record that you will not see him again since you had that quarrel, then if there is complication, it can take you from malpractice and you don't have any good stand. Whereas you have opportunity to hand over this patient to your colleagues, because it's your right to say, no, I'm not comfortable with the way this patient insulted me. There's already conflict of interest. Anything I do will be misinterpreted. To that extent, Dr. B, my colleague, I want to hand over this patient to you. And I'm happy. I'm sure that doctor will be happy to take over that patient from you. You have a right to full and honest disclosure from your patient or relatives. You should be treated fairly and sincerely by the hospital or patient. You should not be insulted or harassed by patients or relatives, again, provided you are doing your work in the way it should be done. For example, again, somebody has an only child, has a ruptured appendix. They didn't see you to come and do the laparotomy and do the appendectomy and do the needful. You disappeared. You didn't come back until 48 hours. That patient dies of septic shock. And when they got there, maybe an only child of the parents, and they beat you up, you cannot say, oh, I have a right not to be insulted. Patient also has a right in the way to resort to self-help in the circumstance like this. We as surgeons should be careful. Of course, you have the right to fair hearing in the event of a complaint against your practice. If something has happened and you're reported to the chief executive, maybe CMD cannot just pronounce suspension from his office. He should call you. Because God himself established this principle of fair hearing in the Garden of Eden. He knew Adam and Eve had sinned, they had erred. Yet he called them to say what has happened. Expectedly, they should call you to say what exactly happened. That is principle of fair hearing. Right to provide with correct tools for your job. This is very important. If your hospital, Lord Dennis said this long ago, that a workman who does have the tools to do a job shouldn't do that job. It's not worth the risk. If the tools should need to do a particular procedure are not available, work to your executive and explain these things. I do not have this tool. If you manage and something happens in the process, you'll be amazed. Your executive will tell you they didn't know you didn't have that tool. That's important for us as surgeons. Then I put it here, right of the surgeon, are you a registered practitioner or you are a quack? And we are talking about registration, it should include basic medical degrees and additional qualifications. I dare say in this forum today, most of our colleagues do not see the need to record or register the additional qualification. I want to plead with us here as surgeons. Go and register your additional qualification if you have not. Because if you have not registered your additional qualification as a surgeon, to that extent of not being registered, you are not really practicing as a specialist surgeon. If there is a mishap and the person suing you knows you are not even registered with medical council as a surgeon, that may first of all demand some explanations in the law court why you didn't register. And it can weaken your case. It can tell the court. You can imagine that it's an irresponsible surgeon. If he was responsible, why did he not do what his colleagues were doing? And when they ask you the question, doctor, why do you not register your additional qualification? You don't have any reasonable explanation to give. Now, having said all this, what is negligence? Negligence is the failure to exercise the standard of care that a reasonably prudent person would have exercised in a similar situation, working in a similar situation. The picture you see on the right there, where the doctor is telling the patient, probably casually, we're sorry, we need to schedule you for another surgery. We accidentally cut off the wrong leg. That, of course, is negligence. It also means any conduct that falls below legal standard established to protect others against unreasonable risk of harm. A surgeon is expected to act in compliance with the standard accepted by a responsible body of surgeons skilled in the art of surgery. Thank God we have a body, colorectal surgeons. We come to conclusions here, we reach some resolutions, this is the way this should be done. If a tumor has spread to this extent, don't go for surgery, go for neoadjuvant chemotherapy. Now, if a surgeon disobeys such injunctions and try to go for a major surgery in the process causes mishap, people will say, well, you belong to this body. This is the consensus. That a tumor of this magnitude, you shouldn't go and attempt surgery. Now you have done the surgery, patient bled to death. That can call for some explanations. But remember, where the surgeon has complied substantially with the standard, it cannot be said to be negligent, even if some harm has occurred. In the particular case of Abbey and Central Bank of Nigeria, here a doctor administers some medications to a patient who eventually became deaf in the process. And the Court of Appeal, according to Wobodo JCA, as it then was, said, the courts have long recognized that there is no negligence if a doctor exercises the ordinary skill of an ordinary competent man professing to have that special skill. But that means that if you have done your own work according to the way it should be done, if there is a mishap, you are not necessarily negligent. Malpractice. What is the legal frame for medical negligence? The Medical and Dental Practitioners Act, MDCN Act, is the legal framework for us as doctors. And therefore, I expect every medical doctor practicing in Nigeria at least to be familiar with this document. Now, there is a thing we call the proof of medical negligence. When the patient says you have been negligent, what are the things that will constitute proof of medical negligence? Number one, that you as a surgeon, you owe the patient a duty of care to exercise that duty of care. That's number one duty. That you as a surgeon have failed to exercise the duty of care. Remember, I explained what the duty of care means. Now you owe the patient duty of care, you didn't exercise that due care, and because you have failed to exercise due care, the patient has suffered harm. Then number four, the law also requires there should be a direct nexus between the injury and the action or inaction of the medical doctor. For example, if you have done a thyroidectomy and the patient is out saying, I can no longer move the left leg, he had a stroke. There's no direct nexus between thyroidectomy and having a CVA. So that is what we need to look at there. Now, what are some examples, I'll run through this, of the things that constitute medical negligence or malpractice with regard to surgical practice? Failure to follow usual practice in the surgical community. For example, it is our practice as surgeons, any tissue removed from a patient's body should be sent for histology. Unfortunately, you hear some surgeons say, I'm so sure this is a lipoma, I'm so sure this is a fibroid adenoma, I'm so sure it's a benign polyp. Who are you to say that? When the body of surgeons have agreed, any tissue removed from the patient's body should be sent for histology. Now, if you didn't send it for histology, you are deviated from the regular practice. And if for any reason that patient has maybe two more recurrence later in that same breast, for example, or that you now have metastasis to the, even you have metastasis to the lungs, that patient will sue you for what we call loss of chance because you didn't follow histology at the beginning. Lack of skill, ignorance, failure to tell patients their risk, lack of equipment, medicine or staff, inappropriate withdrawal of service, breach of confidentiality, failure to see a patient as often as you ought to do, particularly post-op patients, failure to do what you should have done, making a mistake in treatment, making or failing to refer a patient promptly, failure to obtain informed consent, failure to advise or prefer wrong advice to a patient, failure to attend to a patient promptly when you make an incorrect diagnosis. The list is totally endless. Now let's look at surgical errors. Surgical errors are defined as the failure of a management plan to be completed as planned or the use of a wrong management plan. Potential surgical errors can be litigated to establish clinical negligence. There are some common errors we come across. We are familiar with most of these things. Injuries at birth, amputating the wrong limb, excessive blood loss, leaving a foreign body inside the body, wrong side surgery, etc. We are familiar with most of this. Then how can you avoid such surgical errors? Some of them are avoidable. And I put here, we must insist on appropriate use of surgical checklists. Unfortunately, most centers where they use the surgical checklist is just like to fulfill all righteousness. To that extent, you see somebody that want to use the surgical checklist after you have made your incision, is telling you, okay, surgeon want to go to surgical checklist. That's a wrong process. Before you induce anesthesia at all, you must go through these processes. This is the patient want to operate. This thing nearly happened to me. I was just lucky. I want to do a thyroidectomy. This patient they brought to my theater was going to for a ramicolectomy. As my habit, I said, let me just look at the neck again. And I look at the human neck and no thyroid. I said, what's happening? So, Mama, not be your neck one. He said, no, not be that belly, they pain me. I said, Jesus. They swapped the patient from theater 1 to 4, 4 to 1. Just imagine that patient was intubated, you made your incision. So checklist, we must insist it should be used properly. Assuming that checklist was used the way it should be used. Say surgeons, let's agree this, the patient we're operating, you may, Mr. A, B, C, we say yes. We are doing thyroidectomy, say yes. You know, like that, that is the way to use surgical checklist. Caring for minors, I'll dismiss this in a bit. For surgeons, it can pose a challenge. Minors, indeed, we have classes of minors. We have minors, indeed. We have the mature minors. We have the emancipated minors, those that live on their own, or they're in the army, or they are married. The ones we have problem with are the minors, indeed. For the mature minors, they can actually take the decision on their own. You can ignore their parents if you are sure they have the knowledge, they are mature to take decisions. And same thing for emancipated minors. For mature minors, that's where we have problems. You want to do a procedure, you want to give blood, you've done a procedure. The parents say, don't give blood. And you have to say you want to give blood. So for the minors, indeed, who should decide? Ideally, the parents. If it becomes unreasonable, what can happen? Where the guardians can decide, or the courts, or the parents portray. The court can appoint parents, or the court itself can take decision. Then the caregivers, using the emergency doctrine. I must caution here, before you operate on a minor against the wish of the patient, the courts may eventually vindicate you because, you know, the parents can decide to become martyrs of the gospel by saying don't give blood and all that. But they shouldn't really make that child also become a martyr. To that extent, the court will protect you when you go to court. But I have some questions, what I call local challenges. If you're to do the operation, you're to give the blood against the wish of the patient. Number one, who will pay for the blood? Who will pay for the surgery? Number two, where does the minor go to when he discharged? Peradventure, when you want to take the patient to theater against the wish of the patient, you want to give blood. Patient says, if you give this patient blood, we abandon the child for you, and they leave the child for you in the hospital. As a surgeon, what will you do? Are you sure the parents will continue to give care? Even when you discharge, they go home. Will they not reject that child? You have plans for that minor you have just transfused in case the parent reject the child? Do you have laws in practice in Nigeria today when a surgeon has managed the patient against the wish of the patient, the parents, and they say, okay, doctor, you know what, we need the child for you. What do you do in that circumstance? We again dismiss this in a word or two. This child gets medical advice. Now, most of us trivialize this. It's not as simple as it is. Discharge against medical advice can be used interchangeably with a leaving against medical advice. I personally prefer leaving against medical advice because the word discharge connotes that you have let the patient go. I would rather say the patient is leaving against medical advice. Then the other one is leaving before examination. That usually happens in A and E. Absconding, when the patient just disappears from the work, maybe it's owing the bill, they want to pay, it runs away. Elopement. Elopement is somebody, is not owing the bill, is receiving treatment, it just disappears. Probably has some mental conditions. Escape, where a patient is maybe owing a fee, doesn't want surgery for some reasons. Escape is running away against some form of resistance. You see him, you pursue him and all that. In all of this, ideally, it should be documented. The law enforcement agent should be involved in some cases, particularly if a patient left A and E before examination. It may be a criminal. Gunshot injury, receiving care, it just disappears. You don't just say, oh, he left, we can't find him. No, It should be documented. It should be reported to the nearest law enforcement agent, like the police station. We have this patient that came in when we're trying to do our documentations, just disappear. Because if you do not record it, and the person that brought him there say, withdraw the man in this your hospital, you may have to explain what happened to that patient. So, but again, we also need to know that discharge against medical advice or leaving against medical advice is a process and not a mere signature. And it is also dynamic and ambulatory. That means, you know, a patient has the right to change his mind. A patient may have signed against advice today. By next morning, when you come for ward and say, oh God, I've agreed to have the surgery, don't quarrel with the patient. Don't intimidate the patient. Go ahead and do the procedure. Ambulatory. Maybe you work in two hospitals. In hospital A, patient may have declared surgery, assigned against advice. You now go to hospital B that you also cover as a surgeon. Don't quarrel with the patient. Why do you come here now? The man has the right to change. He has the right to change his mind. In that hospital B, perhaps. In hospital B, he probably thinks that they have more facilities and he has accepted to have the surgery there. Again, like I said, the process is more important than the signature. As a surgeon, ascertain the adequate decisional capacity of your patient who want to discharge against advice. Assess the patient's values and application to the situation at hand. Address his concern. Don't just say, okay, come assign. Inform the patient of the risk of refusal of care. Involve other persons when appropriate. Consider alternative treatments. For example, a patient may say, I don't want open reduction or internal fixation. Consider maybe applying a cast, for example, and provide care within what is acceptable to the patient. To that extent, for example, also provide appropriate care and follow up from information. If a patient, for example, that says, I don't want open reduction or internal fixation, that's an open wound. You didn't give tetanus toxoid. You're not giving antibiotics. Just because the patient says, I don't want surgery, doesn't mean you not give antibiotics. Doesn't mean you not give tetanus toxoid. We should also be careful with that. Avoid punitive statements and scare tactics when the patient has said, I want to be discharged. Document the form refusal discussion and outcome. You may need to consider telephone follow-up. David et al. Said that we should commence thorough examination, document it, particularly when you know a patient is very ill. It's very important that you document very well. Documentation can be overemphasized. Then, failure to make, somebody said, a judge, that failure to make appropriate notation of such an important event as refusal of necessary treatment cast doubt upon the contention that it did in fact occur. In this particular case, a doctor tried to say, no, we discussed it and all that. The judge said that such an important discussion, when you know this man was very ill, I have doubt that you actually discuss with the patient. And after they also said that poor documentation remains the great enemy of doctor. And he asserts that the sicker the patient is, the more comprehensive and detailed our progress note ought to be. And Gregory Henry puts it very clearly that the same way we hope to use our progress note to be the patient at the end of treatment or care, that the same way the lawyer will want to study that your document to see there are loopholes that you can convert into notes, naira notes or dollars, as the case may be. Then there are instances when the matter has gone to court. You need to rely on expert opinion. If malpractice case must consider the condition of the patient, the circumstances of the surgery, because some of us here may be called to give expert opinion. You need to look at the patient, circumstances of the surgery, the surgeon's training and experience, while taking into account what the standard of care ought to have been for that patient. But remember also, while giving your expert opinion, that the standard of care isn't carved in stone. What is reasonable will depend on the circumstance. For example, what is reasonable in the US may not be reasonable here, based on the availability of resources. That will bring us to Bolam test, which is also referred to as the reasonable man's test. In this case, where somebody was going to give the electroconvulsive therapy without physical or chemical restraint and the patient had a fracture, the judge said in that case that the doctor has complied substantially with the way it's being done. He complied. He didn't really need to give restraints and all that. Anyway, over time, people went on to the Bolitos test. This test simply says that judges, even though judges ordinarily should rely on expert opinion. Where the expert is trying to turn logic upside down, the judges are not bound to obey you, in the words of Lord Bram Wixon. When the patient is aggrieved, what happens? We talked about malpractice and all that. One, it reports to your employer. You can resort to self-help. You can go to medical counsel. You can go to the court. You can even pray against you. You can resort to any other means. You can use juju to fight you. When a complaint be filed at medical counsel, what are the options? If you are found guilty, they can remove your name from the register. They can suspend you. They can admonish you for a call. That admonition, don't take it to be lightly. You may have gone to medical counsel up to about 5 to 10 times before eventually they come to conclusion. It's not worth it at all if it can be avoided. The patient has the right or the option of going to a regular court. Note also that the medical counsel do not have the jurisdiction to grant monetary compensation to the injured patient. So most patients that go to MDCN, they are not looking for money. They are trying to correct wrong practices so that other patients or relations will not suffer what they suffer. That's the reason they go to medical counsel. Those that want monetary compensation often go to regular court. So for those that go to regular court, the processes can be either through civil or criminal proceedings. For about 90–95% of cases in medical malpractice will fall under the jurisdiction of civil proceedings, which can be commenced by writ of summons, where the claimant tells you to come and give evidence if you have anything to counteract what is claiming. Then you have originating summons, which is actually a matter of interpretation of law. We have petition. In petition, really, that is used either for case of divorce or in election petition matters. We need to remember the cause of action, what we call jurisdiction, and statute of limitation, usually on the average 3 years. If a matter, a patient thing is being mismanaged by you as a surgeon, and it didn't go to court, and it's going to court after 10 years, we say that matter is statute barred. That we call statute of limitation. On the average 3 years. But recall, however, that there are exceptions to the statute of limitation. What are those exceptions? If the patient so mismanaged was an infant at the time was mismanaged. 2, if that patient have infirmity of the mind, maybe he wasn't having the mental capacity at the time for a long time, maybe he had a mental illness for 5 years. When he now regains sanity, he's not lucid, there is an exception to that. Number 3, at the instance of the court, a matter that was ordinarily statute barred for the interest of society, interest of the community, can be made to go on. So you really see as a surgeon, you shouldn't rely on this statute of limitation at all. What are the factors the court will consider when they want to award damages against you? God forbid, if you are sued as a surgeon. 1, they want to look at the payment of the cost of past medical care received by the patient under you, payment for the cost of future medical expenses. You have caused a mishap. Maybe you retain a large abdominal mob in the abdomen. But you're going to have other surgery. When they are going to award damages, they look at that. Compensation for lost wages. He didn't go to work for weeks or months. Compensation for lost any capacity. Maybe due to mismanagement, he lost his upper limbs and so he can no longer walk what he was doing before. Then compensation for mental distress. That share mental distress. Oh, I lost a limb. The court will also look into that and the suffering so associated. Towards concluding, I will run through some cases. In this case, Olabisi Onigbanjo, a doctor left abdominal mob in the abdomen after abdominal surgery. He was suspended for 6 months from practice. In this case, Aro versus Mishra and Silvester, what happened here was that the two surgeons, they did an operation. The patient now had a post-operative fever, and they were called severally. This patient is not doing well, having fever over a 48-hour period. Both doctors did just ignore the call. The nurses also testify. We called them, and they took blood for blood control. They didn't bother to pursue the blood control. Patient eventually died of septic shock. Both doctors were convicted of manslaughter by gross negligence. Remember, I said even though 95% of cases come under civil litigations, in a few instances where a surgeon is be found to be reckless at his work, it can come under criminal litigation. Now, in this case, Mr. Hughes and Iowa Clinic, the prostate gland was removed in error. $12.5 million was awarded against the doctor. for wrong diagnosis and unnecessary surgery. Of course, in Akintade and the Chairman Medical and Dental Council, they define what infamous conduct means. Infamous conduct was also described by Lord Justice Lopez when he said, if a professional does something where his professional colleagues in good standing or good repute, when they hear it, they will say, oh, this conduct is shameful. That is what we call infamous conduct. That's what also the Medical Council tried to say here. We say their own include failure to attend to a patient promptly, it includes incompetence in the assessment of patients, deficient treatment arising from inadequate pre-operative investigation, deficient operative procedure, and poor and unfortunate post-operative management. All that will constitute what we call infamous conduct. In the Kokaro and Tanko, a 14-year-old boy, remember I told you what we call mature minor, his middle finger was removed, one without consent. The doctor didn't take consent, and he just ignored the boy because he thought the auntie was there with the boy, said, do what you think is necessary. And he didn't ask the boy, who was said to be mature. Nicky Toby said, this young boy was very mature in discussion. Why did you ask him? But the young boy kept saying, doctor, why don't you look at this finger? It looks viable, it looks okay. Why don't you leave it if I just dress it? Ignore him, remove the digit, and damages were awarded against that doctor. Two things you can learn from here. You must obtain consent. A mature minor can give consent. In this case of Okonkwo and Medical Council, again, just to summarize this, that as a doctor, you have liberty, you have freedom to manage a patient according to the dictates of that patient. For example, this patient say, I don't want blood transfusion, the patient eventually died. The parents of the patient drag Okonkwo to Medical Council. In error, Medical Council suspended Okonkwo. Thank God Okonkwo knew his right. He went to Court of Appeal and defeated the Medical Council. In error again, Medical Council went to Supreme Court. Okonkwo also defeated Medical Council. And it was concluded that the patient has a right to determine his own medical treatment, and that right is superior to the physician's duty to provide necessary care. A similar decision was reached in Rivers and Court, where the court held that the state's interest in maintaining the ethical integrity of the medical profession, though it's very important, can never outweigh the fundamental individual rights. Then, in this case, they what we call doctrine of res ipsa loquitur. The surgeon may say, okay, let the patient prove the injury is suffered. Don't be deceived. There are some instances where we say the fact speaks for itself. That would mean by res ipsa loquitur. In this case of Mahon and Osborne, where abdominal mop or left in the abdomen. In the case of Fish and Capo, where during a dental extraction, the jaw was fractured. In Cassidy and Ministry of Health, where somebody went to the hospital with one stiff finger, left the hospital with additional two fingers, 4 fingers, I mean. He went there to be cured of 2 stiff fingers. He now left the hospital with 4 stiff fingers. In all of that, we say the fact speaks for itself. The patient doesn't need to prove too much things. The judges will see it. Everybody will see that that doctor may have mismanaged the patient in that circumstance. I put a case there. In this particular case, Garoro and Felicia and DBH management, where a needle got broken. Now, in a Ghanaian woman who had myomectomy, the woman, they tried to look for it in theater, they couldn't get it. After surgery, they told the woman, oh, sorry, we needle got broken and all that. Eventually, the woman had a second surgery, and I went to court and all that. But again, the conclusion for this decision was that doctors, 1, they didn't manufacture the needle. 2, they made every effort to look for the needle. 3, they informed the woman that the needle was there. But the woman too didn't claim correctly. We were talking about the infertility was due to that broken needle. And it was said that broken needle by the location could have even caused infertility. And experts are looking at this case today, currently, that if this case had to come up on all fours, I doubt if the state judgment to be reached, because they will look at the mental agony the woman may have passed through. The forced imprisonment, this happened in Anambra State, where some parents lost a child. They refused to allow the mother and the father to take the child home until they pay their bills. The father went to the court, and damages were awarded against the hospital. And look at the conclusion. The court ruled that the act of hospitals locking up their patients from exiting their premises under the guise that they must complete payment amounted to false imprisonment. In Olaye and Medical Council, there was a rupture ectopic. The doctor didn't see the patient after 36 hours. the tribunal found 5 physicians guilty, including the consultants who were to manage this patient instead of negligence. You know, KZA and medical council, in this case, it was bordered on lack of resources. The gynecologist were going to do a gynae case. It was the surgeon, it was the anesthetist. He didn't have oxygen, he didn't have trained nurses. When there was a mishap, he was suspended from practice for 6 months. The surgeon and the doctrine of vicarious liability, particularly for consultants. We are seeing that, you know, we are the leaders of the ship. The physician is seen as the captain of the ship, and the resident doctor is as a borrowed servant who are belong to the physician in charge of the case. This is very important for most surgeons that you hear them say, I've paid my dues. We have to be careful the way we delegate duties. Then what are some defenses that may be you know, that the doctor can rely on, the surgeon can rely on in the event of being sued by a patient? One, when you have obtained informed consent with proper documentation, then you can rely on the judgment given in Hart and Black by Lord Denny, when he said that not all complications result from negligence, that there are some complications naturally associated with some procedures. 3, the injury is not reasonably foreseeable. Remember, when we're defining negligence, you have to be able to foresee negligence, the injury. But 4, someone else did it before they came to meet you, or there's a pre-existing injury, there may be contributing negligence, which I mentioned earlier. Then Good Samaritan laws. The laws may be milder on you. Maybe you were traveling, you try to assist an accident victim, we couldn't really manage optimally. When that fact is presented, the law may be mild on you. They would call respectable minority principle. I'm glad to see people like Dr. Ugu, Professor Ugu, Professor Rabo, they have respectable authorities. If they do their procedure in a particular way, and a surgeon does his own procedure according to the way Rabo does his procedure, he can quote it. If Rabo is known as an authority, even though it's on the standard textbook, he can say, this is what Rabo does. That's what I also try to do. It can become a defense. Then, of course, we'll talk about statute of limitations. We should consider taking malpractice suit as doctors. Remember, you may be in court either as a defendant, as a plaintiff, or as a witness, or as an expert to give your opinion. As a surgeon, can you really be sued? It's an emphatic yes. If it can happen at all, it can happen at any time. It will most likely happen when you least expect it. When there's a problem, what should you do? Try to avoid litigations, try to be honest, and according to FEMA, the British Medical Journal, meant to say, I'm sorry. That can help you to prevent some avoidable embarrassing situations. Then learn to adopt alternative dispute resolutions. Also learn to get the service of a lawyer very early. Don't talk too much, or you can actually refuse to say anything when you hear the patient try to go for litigation. Ensure your lawyer is around before you follow a policeman to the police station, try to avoid embarrassment. You must also maintain inter-records, but do not falsify. In conclusion, ladies and gentlemen, lawsuits for medical negligence can be minimized or avoided by taking steps to keep patients satisfied. You must be familiar with their rights and respect those rights. You must adhere to policies and procedures, develop patient-centered care, and know the ways of defending against medical malpractice judgment. I put it here again in red: documentation, documentation, documentation. It can never be overemphasized. Having comprehensive professional liability insurance is a necessity in the present day litigious society. We must see every patient as a potential litigant. Any patient you are putting under the knife, see that patient as a potential litigant. Never make the mistake of underestimating any patient. That patient you think is timid may not actually be timid. And the world has now become a global village. Because a case that is decided in the US happens here in Nigeria, the patient may want to test the law to see if judgment will also be given his favor. But I put it here as my last point. Above all, according to the documentations in Matthew 7:2, verse 12, in everything we do as surgeons, treat that surgical patient the way you would love to be treated if you were to be a surgical patient tomorrow. This is perhaps the shortest way to avoid litigations. Thank you very much.
Yeah, thank you very much, Professor Osime. It looks as if we should keep talking for the next 1 hour, but time will not permit us. We really appreciate you for that exhaustive discussion. Now the floor is open. This is 9 o'clock, so we have just 30 minutes to finish today's meeting. So if you have questions, please post them so that our rapporteur can coordinate them and put them together to, across to Professor Osimen. While that is happening, please permit me to just state 1 or 2 things. Number 1 is that you made mention of an example. For example, if a surgeon forgets a gauze or an abdomen in the tummy of a patient. But sir, we all know that it is not the surgeon only that participated in that surgery. At the end of the surgery, there should be swab count by the perioperative nurses. Okay, so if the perioperative nurse did not do his or her swab count, is it justified that the surgeon alone now is held responsible? That is on one side. The issue of checklist, I don't want to overemphasize that. I think it's what we should all come to terms with. Then another thing that I think also stimulates litigation from my experience, especially from our practice in Nigeria, is the so-called superiority complex attitude of some of our colleagues. Permit me to say that, for example, if you refer a patient from a center to a higher center, once the patient gets there with the referral letter, it will amaze you the way some of our colleagues behave. They first of all look at the referral letter and start all sorts of derogatory statements. You mean that this is a person doesn't know how to do this procedure? Imagine, in the presence of patients. This has happened to a lot of us. We refer patients to a higher center only for our colleagues there to start talking all sorts of things. In fact, one of such instances, the patient even came back that he was going to sue the other doctors there. It took the intervention of some of our senior colleagues to actually down that tension. So I think our attitude too, our utterances, we need to guide them. Then another thing that I listed here is the issue of the DAMA and the operation consent form. If you look at most of the operation consent form we use in Nigeria, they are quite scanty and shabby. I think those operations, especially in government hospitals, I think our operation consent form should be more detailed to protect the surgeon or the physician to some extent. But if you see some of the consent form that we use in government hospitals, just maybe 1 or 2 or 3 lines, which personally I believe that it is not acceptable by any standard anywhere in the world, talk less of the court of law. And then same thing goes for the LAMA or the DAMA. I think there should be a LAMA form where some of those things will be documented. All these things is to protect the practitioner, not just say that a patient said that he wants to LAMA and let the patient go and sign, just like what you have said. Then lastly, in the area of this technology, I want us to be more careful because I had an experience not too long ago where a surgery was done by the gynecologist. There was complication, intra-abdominal abscess. So general surgery had to step in. So we drained the abscess, everything went fine. But the relatives actually wanted to nail the gynecologist. So they met me after the procedure. They were asking me questions. They were actually trying to throw questions at me. Okay, I was able to actually pick my words and I spoke very little, not knowing that somebody put a recorder in the pocket. So everything I was saying, they were recording. No, unknown to me, I got to know of that recording about 2 weeks. Because they went to go and play somewhere and somebody now called me that, thank God that I didn't have got so much information. I said, why will I put my colleague in trouble? For what will I benefit by doing that? So we should be worried that patients or patient relatives could actually be recording our conversation secretly and we will not know. So let us guide our thoughts. Let's choose our words. And if we are not sure of what to say, it's better to keep quiet or maybe to refer them to a more senior person. Thank you. Dr. Eguari, you have the floor, sir.
Thank you very much, Professor Osime. I think this is a master class, and anybody that missed this, you may read the slides, but it's nothing compared to just listening to it live. And I think we really need to appreciate you for this. This is an absolute master class, and we need to get to this myself and just go through it again. Yeah. So I know there are questions coming, and just I don't even know where to start. It's just everything is so self-explanatory. But one of the things I want to say is about the peer review you talked about, and looking at our system in Nigeria. How workable is it? Because people just willy-nilly, everybody can do anything they want to do, and there is no regulatory mechanism to check. And it's just amazing that all this happened in Nigeria, all these case laws that you quoted. I don't know, how much of this kind of education is available for people, because if we do more of this in a different forum, it will kind of awaken people's awareness as to what our duty of care is to patients, and just a lot about what you said, particularly that area of duty of care is something that we need to be, very aware of. You just don't do things. And, I have been, a recipient of that. And I had a relative in a hospital in Nigeria, and I knew that some things were not being done right. I wanted to speak to the consultant, and he got very angry and just won't talk to me anymore, and those kind of things. I'm just wondering why it happens and what we can do in terms of the medical education to our trainees.
Thank you so much, sir. So maybe I will just respond at once if we can take all the questions so we can manage time.
Okay, and then the other question there is, in terms of this recording, I'm just wondering, I don't know what the legal status is. If somebody records you without your consent, is that admissible in court? Because there's a question here that says some patients come with recorders to record discussions. What is the validity of that evidence? Is it admissible in court? And then the other question there says, what are the options to recover hospital bills when a patient refuses to pay? Okay, we'll let Professor Osime answer those questions.
Okay, that's fine.
And if you have other questions, you can put them on the chat. And
yeah. Right, thank you very much, my senior colleagues and my colleagues. Thank you for the questions, comments. So I'll start with the first question by Dr. Adejumo regarding issue of swap and count and the theater nurses. You are very correct. Ideally, you are supposed to have a circulating nurse who counts with the scrub nurse. What you discover with the shortage of manpower just now, you'll be operating with the scrub nurse only, no circulating nurse. That is a major challenge. So what I do, for example, for me, is on our own, when we finish, we make every effort to check every crevices where we operated. Whether it's tenoidectomy or laparotomy, that would have taught my residents too. They know it. When we finish, you put your finger in every crevice. Because to go to court, you are going to have a defense that the nurse counted and said it was okay. But it's not funny going to court. For me, if it can be avoided as much as possible, try to avoid it. That's what I would say. You have a defense. You are not a magician. You are operating very hemorrhagic, very, surgery. People have bled so much, using many guns and mobs and all that, and not say complete. And you close and came out. When you go to court eventually, they are going to call experts. What is standard? That is standard practice. The nurse announces that's complete. But you ask yourself, will you be ready to be going to call medical counsel and all that? Well, if the hospital doesn't support you, that way you're going to have problems. If the hospital doesn't support you in that course, if they have sued you. And don't forget also, as the surgeon, you are the owner of the patient. The doctor doesn't know the nurse. They don't know the meaning of scrub nurse. All that explanation will be given at the medical council or at a regular court. So that is the way I will look at that. Then what you say about referral and the regretted comments, you are very correct. You are very correct. I won't mention some specialties. It's the thing we must talk to ourselves in forum like this. Please, when somebody refer to you, don't become arrogant because of the particular location you find yourself. That you said in the Bible, time and chance. You're only just lucky to have been in a location where you are, maybe where you have a particular facility available. It does not make you a super person that when the colleague writes to you, you will scrutinize, even if you saw some errors in what they did. I expect that you call your colleagues and say, this is what you observe. So when you refer a patient and you hear comments, the mastectomy was not properly done at all. You didn't know the extent of the tumor, you don't have the details, and you make such comments in presence of patient, it must be discouraged. There's so, but I don't know how best to say it, should be discouraged. Then, yeah, the DAMA form and the consent form, you are very correct. The DAMA form we use is on detail. The same thing with the consent form. Again, I don't even think we know the meaning of this at all yet. We pray that someday we'll wake up. I personally, in my facility, right, I made a presentation. I projected a detailed consent form, which I thought we would discuss with the management to see how we can adopt it. That presentation, the last day that they presented it was the last time it was talked about. And you ask yourself, why would you now say, spend all the energy, try to design a detailed form, which we thought we could pass through the hospital legal unit and adopt for the hospital? You know, somehow that has kept my interest and enthusiasm to pursue that. But ideally, I believe by now, we should do away with the consent form you see in our case note, which actually means nothing in the event of serious litigation. For gunshot, somebody asked a question. I would advise that you find a way to inform the police. I gave you a typical example of the leaving medical advice or leaving before examination. It happened typically in A&E. Gunshot injury, it happened recently. I won't mention the hospital. Recently, this happened. Even after I prepared this slide. Gunshot came to A&E. I'm sure he probably got information they were trailing him. It disappeared. When police came, where is this one he has left? And you can imagine the embarrassment. The person in charge of that unit, we have to give explanation. Where is Mr. ABC that registered under your facility? So where if you have made a proper recording and all that, so you won't have that embarrassment. So for gunshot cases, one, you should find a way to report to the police station. We must do this also carefully because the society will find ourselves. Some patients are criminal hooligans. They can attack you. They can attack you if you maybe deny the treatment and let me get a clearance of police first. No, and you know the law of today just now, treat the patients while you're making effort to report the matter. So you don't deny them treatment, but even try to report, you have to find a way to do it discreetly. Don't make it too obvious. Because if that patient gets to know when you go to court and all that, they can come after you. You're also required to be careful in doing some of these things. In recording, I'll take that with Dr. Guare's comment. Yeah, ideally, nobody can record you or photograph you without your consent. But you also know, in this era, I'm sure some of these things will change with time. I'm very sure of that. It's evident, will change. Because our laws, they are hardly ever reviewed. But as of today, nobody can record you without your consent. Nobody can photograph you without your consent. But having said that, and to that extent, it won't be a valid legal document. To that extent, however, you must be careful. There are patients are very, like what Adeyemo said, they are very clever now. They can record you. And whether they accept it or not, he can wiki your case, you might make some comments, which his lawyer will play. Even though he's not going to tender it, he will extract certain things for what we are saying. And because you actually made some slips, which you know, well, you are talking genuinely, then it can be used against you. Then peer review, someday we hope we'll get there. Now I said at the beginning, I'm happy this society is here. We can have our ways to say, if somebody has a colorectal lesion, this is standard of management. And we expect every doctor to try to manage that patient in that area. If you have managed that patient outside that protocol, You should be able to present to a house like this. This is the reason why I chose to manage this patient in this manner. They will critique your approach and maybe learn from it. But you cannot demonstrate impunity. I do it the way I want to do it, because when the chips are down, that's where expert opinion comes on. Your colleagues will be called, who are in the society, for example. And maybe they will say, it's a member of the society, say, where did you get this your opinion from? And you now have harmed our person. So we need to appreciate peer review. When they critique your work, don't quarrel. Subject yourself, your work to analysis. Let people look at what you have done. And don't pick a quarrel. Are you trying to teach me what to do? I'm a surgeon. The surgeons you want to devise means, yeah, why you would know you can do certain things on the spot of the moment, which may not be documented in books and all that, but major things we do should be according to protocol. And that should be from time to time, we should have a peer review of our activities. But I can tell you, standards are eventually emerging, sir. Standards are emerging. Then the duty of care, you link to telephone phone calls. What you described is very true. I've experienced it myself, not once, not twice, several occasions. When a relation will be in A and E, and he says, I'm here, doctor, please help me. I said, okay, give the phone to the doctor. Perhaps they don't even, and you say, Prof, Osime, I want to talk to you. Maybe the person doesn't know who you are. He said, no, please, I don't want to talk to him. Please, let us talk to our colleagues, talk to our residents. It is not a good practice. It's not a good practice. That's why I put my last statement there. Do unto others what you want them to do unto you. If you're in such a position, how will you feel? You want to talk to your colleague about a relation of yours on admission, and he just want to hear you. It is all right. That I don't know, a stronger way to express is very wrong. Some doctors, with due respect, demonstrate arrogance, and we must discourage it. And what I said at the beginning, we must maintain friendly attitude and disposition. Because if you are hostile to your patient and there's a mishap, the threshold for litigation is very low. But if you are friendly and there's a mishap, they will be the one telling you, doctor, you did your best. You did your best. That is the way we must try to practice medicine. Yeah, how do you recover your bills? Well, it's unfortunate. What I will suggest for elective procedures, if you are run a private outfit, as much as possible, try to collect substantial part of your money. That's number one, I would say. Because the law today, if a patient has been discharged and you have written there, discharge this patient to go see an SOP in 12 weeks, and you are keeping the patient because he has not paid his forced imprisonment. The case I presented happened in Anambra State. You know, every time I presented forced imprisonment, I said, how do I get my money? Until that case was decided in Anambra State. They wanted something in no hospital. It's a mission hospital where the baby died. They insisted they must pay for the go. And they went to court. They defeated them. When they said they should pay 500,000, they were pleading. The hospital was pleading. Sorry, it's a mission hospital. It's just a well, just to be lenient. It's a mission hospital. You still pay that amount. We spread it over 1 year, but with the interest accruing. Of course, that meant they were able to pay more than the 500,000 naira. The point I'm making is, you have to find a way to get money. What's the other way? When I say a doctor in court, a doctor can be in court as a plaintiff. You sue your patient. And I can tell you, the judges, the courts are very willing to support you to recover your money. But you also ask yourself, if there are other ways to avoid this, why go through that route? Therefore, for elective cases, I repeat, collect your money upfront. If you're going to do a mastectomy, thyroidectomy that is not obstructing, there's no reason why you go and do operation for start asking for money. But for emergencies, where you only hope you have patients who are not troublesome. But the law as of today, if you were to hold a patient not to leave your facility because he has not paid, it is forced imprisonment. Thank you very much.
Thank you very much, Prof. Osime. Just to make a comment on this issue of the quality in terms of swabs in the abdomen, I think if we look at the World Health Organization surgical safety checklist, the prime responsibility is still that of the surgeon. And there are different stages where you have to do your checks. Before your patient leaves the day ward to come to the theater, the handover from the day ward nurses to the theater nurses, the check takes place to be sure that this is the right patient and the site has been marked. Then the patient goes into the anesthesia induction room. Again, before the patient is put to sleep, the surgeon has to be there to sign that they have checked the marking and everything. And when you are finishing, you have to announce to the nurses, we are finishing, we are closing, and then they have to stop to do the cavity count to be sure that everything is complete. And if it's not complete, you can't proceed to start closing. And even when you finish, everything again has to be counted, and then you recount the procedure you did. So it's something that just has to be built in. You don't come as a big boss and you say, well, nobody talks when I'm operating. You just go and make an incision. All these things these protocols are put in place to protect us. And we should develop that culture of really letting everybody get into it, you know? So if you have a culture in your theater where nobody can talk, even when your trainee knows that you've left a swab there, they're even afraid to tell you. You see, that is one thing. So we had a conversation here some time ago when one of our colleagues was telling us we need to develop a culture where your colleagues, your trainees, your juniors should be able to talk to you and say, Chief, something is there, you know? And when people are so afraid to tell you something, that's somewhere where things happen. And then in terms of the consent form, I agree with you, many places, even over here, consent forms are not worth the paper they are written on. You may write it, but it's still not worth it when it gets to court. So what, for example, I have done in my hospital, there is this private setup that have done information leaflets about procedures. And I think so what we do now is we have them, and once a patient comes into the clinic for any particular procedure, you just print out the information leaflets, discuss it with the patient, give it to the patient, dictate that in the letter that you have given the patient information leaflet SP035 or something like that. And when they come to the hospital for the procedure, then they have to sign the consent with somebody who knows the procedure. It's not just enough to send your intern or your senior house officer to go and take a consent when you are doing a Whipple's procedure, a procedure they've not seen before. So these are things that are important in terms of, you know, duty of care. Informed consent means exactly that the person who is giving the information knows exactly what they are doing. So let's be careful about that. And then Professor Osime also said something about some of a patient who maybe hit a bottle of Coke and drank it before coming to theater. So I don't know what level of checks, you know, patients go through before they come to theater. One of the places I have that difficulty is patients that have just had a CT scan and the anesthetist will not put the patient to sleep for another 4 hours because of the contrast, you know. So if the anesthetist will always go back and check to find out when the patient last drank, and they will tell you, no, this patient can't be done now until, you know, and the gastric clearance time. So I don't know whether that conversation goes on with the surgeons back home in terms of determining, or would the big boss just come and say, no, I want to do this case, I want to do it now, or something like that? Who takes that decision?
Yeah, you know, when I mentioned that under contributory negligence. Contributory negligence, what I mean is that the patient, you know, is told what to do and he disobeys the rules. And if anything happens and there's evidence to show that he didn't obey the rule, instruction you gave, that patient is said to be negligent on his own, and his claim against the surgeon will be weak. That was the point I tried to explain with that. Yeah, you give some instructions, give some drugs for you to take, for example, he doesn't take it. And if something happened because that drug wasn't taken by the patient, and there's evidence to show he was given, he didn't take it, he just ignored, take it, then of course, you can give some protection or some defense to the surgeon.
Okay, thank you so much, Prof. And Professor Ade Osino, I think wants to
Good afternoon. Good afternoon, everyone. Can you hear me, please?
Yes, we can hear you clearly.
Yeah, thank you, Professor Osime. Thank you. Regarding consent form, I think, like the Professor Osime mentioned, I think we as surgeons should be the ones signing the consent form ourselves.
Yeah,
we should discuss. We should discuss the complications with the patient.
Yeah.
In case in point, you're not doing a colonoscopy when you know there's a likelihood. We really perforate. But the patient should know a perforation can occur before coming for a colonoscopy. A case in point, I had a lady that came for a colonoscopy 2 weeks or 3 weeks ago. The lady said, oh, she won't have a perforation. I was very happy when she said that. I said, that means you've read about it. I said, it's a possible complication, but it can't happen in expert hands, and if we're extremely careful. I think consent form should be signed by the operating surgeon. The patient, you are doing a low anterior resection, for example. The patient can have erectile dysfunction, bladder problems. The patient should be aware before surgery. If the patient is aware before surgery, and if it does happen, the likelihood of you being prosecuted, being liable may be reduced because he or she has been informed before surgery. Thank you, everyone. Thank you again, Professor Osime.
Thank you very much, Oshinowo.
Thank you, Dr. Oshinowo. Please, Dr. Olaomi, 1 minute. Dr. Olaomi, I spot Dr. Olaomi in the meeting.
Well, thank you, Professor Osime.
Thank you, sir. Olaomi, how are you?
Yeah, I'm good. Well, thank you for the lecture. I think some of the important points have been raised. I've been to court about the patient that took me to court because the patient died a few minutes after colonoscopy, though he was alive when I left the colonoscopy room. Eventually, they just wanted money, and everything they did in a hurry. They never really got anything out of it. But the agony.
Can you speak up a little? I'm not hearing you.
Okay. I said, I've been in court post-colonoscopy death, though the patient was alive as at the time I spoke with me, as at the time I left the colonoscopy room. But with everything they did, whatever they wanted to claim, it did not work because there was documentation. And there's another thing our colleagues needs to be. We talk about the documentation. Even your case notes should not be left where the relatives are. Because in this case, I'm talking about the wife was a staff in the hospital, and the case note was with the staff. Everything was with the staff. So, and they tried to do away with things. They removed the consent form, but we were able to show that this was signed by us, and they were the one. It was the woman that took things and was removing documents from file. So the lesson here is that it's better not to go through all these ASUs. And if we do our work correctly, interact with your patients, you are not likely to fall into errors because patients will ask you questions. You are not lord over patients because these are another area that we need to be careful. Even if your patients makes you to feel that you are lord and master, you need to come to realize that you are just to help them, assist them to recover, and you are not lord. In picking telephone, it's a very common thing. Even with me here, I want to talk to somebody in my casualty because they don't really know me now. They refuse to pick phones. When I now get there, they say, they are sorry, sir, they are sorry, sir. Pick phone and listen to what the other person at the other end wants to say. It may be an information that will help you in the management of the patient. Or we even make you to be very careful to know that, oh, you may run into problems in this case if you don't do things right. Then our attitude, as Dr. Adejumo mentioned, that's criticizing everything that comes to you because it's not you. And you have heard you don't know what the other colleague has gone through. And for somebody to send the patients to you, it's enough for the person to say, look, I have limitations here. You continue the management of this patient. And if you need any other information, you try to get to the other doctor. These are the ideal things to work. and it will help everybody. Most of the litigations, I will say that I know, is because somebody has said something negative about the management of that patient in that hospital. In most cases, that is when the patients are primed or the relatives are primed and they want to go to the court. So we all need to be careful. We need to be a brother's keeper. Even if you think there's an obvious negligence or mistake on the part of the physician, you should discuss that with the physician, not with the patient's relative or with the patient. I've had a case where a CS for ruptured uterus was done in one of the FCT hospitals. And the doctor, for whatever reason, should have removed that uterus, but decided to repair. That was the first baby. The baby died. The doctor repaired the uterus. But in that process, artery faucets fell behind the uterus. And 2-3 months after, when the patient was, they don't discover that. They removed it. The patient had 2 babies and still decided to go to court. And they brought the patients to me because we removed the artery faucets, that you come and be a witness. And I told the lawyer, are you sure you actually want me to be a witness in this case? And I explained to the lawyer that I will be happy to give evidence against the woman after 2 children. He should be happy that that doctor gave her the opportunity to have 2 children. If not, she wouldn't have had anything, because if he had removed that uterus at the first instance, the opportunity for those children would. And that was when the lawyer himself now said, is that how the case? I said, yes, that is it. You can blame the doctor for not removing that uterus at that point. But can you blame that doctor for giving her the opportunity to have 2 other children alive? That was how the case ended. So we also should help our people. We should help ourselves in education and in what we do. Thank you, Professor.
Thank you, Dr. Olaomi.
Thank you very much, Olaomi.
Yeah, but I want to call Professor Etioma. 1 minute, Professor Etioma. 1 minute, sir. Maybe profs are not listening. Professor Ogusa.
Thank you very much. Thank you very much, Professor Osimen. That was a master class, as Dr. Gare had mentioned. I think you touched most of the things we make in our process. I think that what we've just heard should be integrated in our revision courses, so that the residents can hear it firsthand and begin to implement it in their practice. If we just finish with it here and we don't move it up to be integrated, so that every resident will at least get to hear this. Number 2, you mentioned issues that relate to guidelines. What needs to be done for particular cases? That does not mean that people have not gotten their certification, but this is how things should be done, following an algorithm. I think that we have not come to this surgical audits, because you can't do surgical audits without guidelines. And guidelines are usually established by the national and regional surgical bodies. In this case, National Postgraduate Medical College, West African College of Surgeons, Ghana College of Physicians and Surgeons, the CES, the Francophone. It's time we started thinking in this line. I'm sure that Dr. Iguare can throw more light on the issue of using guidelines in our work. I think it's very important. And if we start with colorectal diseases, it will go a very long way. So maybe I'll just hand it over to Dr. Iguare to maybe shed more light on what they use guidelines for, particularly in the case of colorectal disease. Thank you very much.
Yeah, thank you very much, Prof. Yeah, I think, you see, like I said, first of all, protocols are meant to protect us. And when we have these guidelines, then it helps you, not that it makes you a robot and you're just, yes, if yes, do the next one. You know, that every procedure now, we have guidelines. You know, for example, colonoscopies. And who do you do a colonoscopy for? How often do you repeat the colonoscopy? What are the indications for your colonoscopy? What are the histology, the biopsy? How many biopsies do you take for your colonoscopy? When do you do random colonic biopsies? When do you do, you know, EMR? So all these there are guidelines that guides every thing. Okay, when it comes to colectomy, when do you do a laparoscopic right hemicolectomy? When do you do a neoadjuvant treatment for a patient? You know, and all these are, and then even when it comes to histological evaluation, there are guidelines in terms of the reporting system. All the reports, they follow the same system, so that everything is, you know, follows a guideline. And once you do it the way the guidelines recommend, then you don't run into trouble. You know, even when every procedure, we are dealing with rectal prolapse. What procedures do you do for your rectal prolapse? What are the evidence that support the technique you use? And why did you choose to do that? You know, what technique do you use? Do you do a DeLorme's? Do you do an Osime? Do you do a laparoscopic ventral rectopexy? All these things, there are guidelines that determine what you do for a patient. And I think it's something we need to develop, but I think this is a good starting point that we all should attend. This is a course that if I was asked to pay for, I would pay to attend it. You know, it's just an absolute treasure trove for us. And if everyone gets, you know, acquainted with this kind of lecture, then it helps us to begin to think about it. But just to, agree with Professor Ogo there that we should begin to, you know, really develop guidelines. But again, I have to be, you know, cognizant of the fact that guidelines, again, you know, demands resources. So we can't make guidelines, for example, in Nigeria that does not have the resources to actually implement them, because you don't end up not being able to even offer a reasonable treatment to the patient. So I think these developments will go hand in hand, that once you have guidelines that genders or, you know, creation of the resources, and that there's a willingness for us to actually recognize for those guidelines to be fully implemented, there has to be certain resources to go with those. Maybe these are some of the things we should be discussing at later dates. Professor Adejumo and the ESCO, just to get our professors at home to say, you know, to talk about guidelines as to, you know, in terms of resources available and how we can reasonably use those guidelines. But for us here, everything you do is with guidelines. And again, it's because of the indemnity cover. Your hospital covers you in terms of medical indemnity. When something goes wrong, they want to be sure that they are not going to be paying unnecessary because of your carelessness. So once you have followed the guidelines and things still happen, then you are protected. And that's the essence of, you know, using those guidelines just to protect you. So if you go to court, you could say, well, I did everything the way the guidelines said it should be done. However, you know, sometimes you do everything, the cookies still crumbles, and that's life, really. I just, Mr. President, there's a question by Dr. Chukwu Lebe about the trainees of older consultants, and now that you have subspecialties, what should be their fate? I don't know if we have enough time to discuss that, or if this kind of topics should be channeled for another day.
Yeah.
You know, so if we can record the charts, I think they are all very important, so that we can then look through them again and select some of the questions there that we can use our technique for further discussions.
Yes, sir. Thank you, sir. One of our proposed topics for this year, I think before the next quarter, is to have a discussion on professional advancement. So we will look for a way of incorporating everything together, and this question will fit into that particular forum when the time comes.
Okay.
Dr. Irotula?
Yeah, thank you very much, Dr. Osime. I think that's an excellent lecture, inviting us to defend the interests of our patients, because while we do that, we defend our own interests too. So it's a very good start. We here in Italy, and like Dr. Iguare, we are born into practicing guidelines. So to us, it looks natural, but I think it's a very good start for us to start it in Nigeria, make things work the way they should. Thank you very much for the evening.
Thank you so much, sir.
Yeah, on behalf of the ESCOs and the entire house this evening, I want to say thank you to our trainer, our father, Professor Clement Osimen, for this wonderful and enlightening presentation. In fact, I'm tempted to say that probably before the year runs out, we will take another module again of this medical legal discussion, so that at least the more we keep talking to ourselves, the more we imbibe some of these things. I appreciate our diaspora partners, and I also appreciate our trainers who are in the house. Time will not permit me to mention their names. I appreciate my colleagues from different centers across the country for attending this program. For our information, this presentation is recorded. It has been recorded, and we are going to do the edit and upload it to our YouTube website. So in case you want to watch it over and over again. So also all our previous episodes on this platform have been recorded and uploaded to our YouTube page, so which you can easily access. So I would thank you once again, and I pray that by tomorrow we will have a new leadership of the country that will gear us towards the next phase of the political dispensation. Thank you, everybody, and good night.
Thank you so much.
Thank you very much. Good night. God bless.
Good night.
Thank you so much, Prof. Osime.
Thank you, everybody. Good night.
Thank you, sir.
Bye.